John Stuart Mill, an English philosopher, concluded that truth can only emerge from the clash of contrary opinions. Therefore, robust debate must be permitted. He believed in free speech because he believed that when free speech is allowed, there are both sides on an issue, and thus truth can emerge from the merits. However, when children are forced to represent themselves, it results in one-sided proceedings where truth and justice cannot emerge. It is because my partner and I believe that the pursuit of truth in the courts can only be achieved by two opposing sides we are resolved. The federal court system should be significantly reformed. Before we examine the current system, we must clarify one term: federal court system. Federal courts handle all immigration, bankruptcy, copyright, patent, and federal criminal cases. The United States has federal immigration courts to deal with immigration cases. That being established, let's look at the goal by which we achieve success. The fundamental goal of any court system is justice, which is our goal today. Upholding justice has two prongs to it: efficiency and accuracy. Courts should be efficient, making decisions as quick as they should, and accurate, making the correct decisions as the law demands. Any reform toward the courts should be geared toward helping the courts be efficient and make the right decisions. Next, let's examine the fact of the current system. Children have no lawyers. Children have no lawyers. The past few years, the U.S. border has experienced a surge in the amount of unaccompanied minors crossing the border. Unaccompanied minors are children under the age of 18 without a legal guardian who enter the United States. They are fleeing untenable violence in Central America. Once in federal custody, the children are put into deportation proceedings to determine whether or not they are allowed to remain legally or be deported, depending on their specific situation in the immigration courts. Immigration judges are supposed to make the right decisions. For children who are eligible under the law, they should allow them to stay. And for children who are not eligible under the law, they should be deported. According to the most recent data published by Syracuse University in May 2016, there are currently about 68,000 unaccompanied minors with cases pending in the immigration courts. Now, because unaccompanied minors have no legal right to lawyers, only private organizations called pro bono are able to provide counsel. However, these pro bono organizations are overstretched and unable to represent all of the children. Therefore, since the beginning of fiscal year 2016, only about 25% of unaccompanied minors were represented. That is a representation rate of 25%. We propose a plan to remedy this and restore justice. Our plan is to appoint legal counsel for all unaccompanied minors. Appoint legal counsel for all unaccompanied minors. Congress shall reform federal law to require that any immigrant who is under that age of 18, is unaccompanied and unrepresented in the immigration courts, will be appointed a lawyer. Said lawyers will be appointed by the Department of Health and Human Services and will be able to counsel unaccompanied minors. This mandate will be passed and enforced by any necessary parts of the federal government. All necessary funding provisions will come from cutting the education part of the program Head Start, which will provide $8 billion annually. Our plan will be passed immediately and be given 6 months for implementation. Now, there are two main reasons, or justifications, to pass our plan. Let's begin with the first. Justification 1, improved court accuracy. Improved court accuracy. In 2014, a study was published weighing the costs and benefits of providing lawyers to every unaccompanied minor by the National Economic Research Associates, the New York City Bar Association, and Wilmer Hale, a consulting firm. The results may be startling. Farron Anello and Lenny Benson, professors of immigration law, and Dr. Michael Cooper report on the findings, quote, to provide government-appointed counsel for each of these children could actually save money for U.S. taxpayers. What the National Economic Research Associates found was that the savings to the federal government from detention, foster care, and transportation outlays would pay for most, if not all, of the cost of providing lawyers. Why? Because for those with a legitimate claim, attorneys provide the evidence and arguments courts need to make quick decisions and avoid prolonged procedural delays. And for those without a legitimate claim, attorneys counsel them to go home, voluntarily. So there is no need for prolonged detention or foster care. And the study did not even count the savings that appointed counsel will generate from an estimated 87,000 fewer court proceedings and 115,000 fewer hours of court staff time, end quote. In other words, counsel streamlines proceedings. It would streamline proceedings such that, in fact, it would save 87,000 fewer court proceedings and 115,000 fewer hours of court staff time. Now, first of all, this is because for children who are eligible under the law, lawyers help the courts to quickly determine that the child is, well, eligible. Take the example of Arturo. Arturo is a 3-year-old who arrived at the U.S. border in April 2014 because family members feared for his life in El Salvador. Although he is only a toddler, the government has to put him into deportation proceedings on his own. He has no attorney to help him explain to the court why he should be allowed to stay. How can a 3-year-old represent himself in court? Now, although most unaccompanied minors are not toddlers, this illustrates the point that lawyers will increase efficiency. Lawyers can quickly file applications for relief. Children cannot. Lawyers can quickly complete complex legal research. Children cannot. And lawyers can quickly file motions. Children cannot. The study also found that for children who are not eligible under the law, lawyers actually encourage them to voluntarily self-deport. Dr. John Montgomery, who holds a PhD from Princeton, says, quote, "Many detained without any chance of relief will accept deportation more quickly if well counseled," end quote. This is a very important point. Not only do lawyers help children who are eligible under the law, but for children who are not eligible under the law, they encourage them to voluntarily self-deport. When immigrants voluntarily self-deport, that is the best solution. It saves court resources, it reduces detention costs, and upholds the law. For these reasons, appointed counsel will improve court efficiency. This brings us to justification 2, improved court accuracy. Improved court accuracy. Right now, these children are facing trained government lawyers arguing they should be deported. This can lead to one-sided proceedings and unjustified decisions. Guaranteeing counsel would help this by enhancing fact-finding. Professor of Law Russell Wheeler, who has studied the federal courts for over 20 years, affirmed, quote, "Two competent opposing lawyers arguing a point provides a judge assurance that she has the best information she's likely to have," end quote. We agree with Professor Wheeler. When there are two opposing lawyers, judges can see both sides and focus on the merits. This is especially true for cases involving children because they have a hard time representing themselves. Because of this, judges will be better able to make the correct decisions. Anello, Benson, and Cooper, whom we quoted earlier, say, quote, "Immigration judges have voiced support for appointed counsel because they need assistance to accurately determine which children need protection from persecution, trafficking, or abuse," end quote. From this citation, we see immigration judges, the ones who know what's best for their courtroom, the ones actually deciding the cases, support the affirmative team's plan. Judges know that guaranteeing counsel will help them make the right decisions. The impact of this is that guaranteeing counsel upholds judicial accuracy. When children have a lawyer, judges make more justified decisions more efficiently. For children who are eligible under the law, lawyers help them to win their case. For children who are not eligible under the law, lawyers help them to be deported. Regardless of one's opinion on immigration, we all agree courts should rule out the law as accurately as possible, which is why our case is not about immigration, but justice and truth in the courts. Thank you for your time.
Really don't have to keep your jackets on.
No, it's all right. I'll just take them off myself. Are you set? All right, okay, go ahead and start. Hi there, I trust you're doing well this morning. Can we please have a copy for when I see?
Absolutely.
Thank you.
Complete citations and statistical analysis are at the back.
Thank you. Now, how large is the backlog of children that are not being represented currently?
There are about 68,000 unaccompanied minors currently pending in the immigration.
Right. When does the vast majority of these minors come into the system, enter the system?
The surge in unaccompanied minors started in 2012, and ever since then, there was a large peak in 2014, which was the year where most of them came, and 2015, a large of them came as well, with record numbers coming in the early months of 2016.
Okay, thank you. Now, what is the name of this adjudication entity that you guys are reforming here? What is the name of the court that you guys are reforming?
The immigration courts.
The immigration court. Can we not agree that that court is the EOIR, or it's officially known as the Executive Office of Immigration Review?
The EOIR is the body that is overseeing the immigration courts.
Now, can we also agree that all courts have an appellate court that they can appeal to?
Yes.
Okay. What is the name of the appellate court that this court appeals to?
It first goes to the Board of Immigration Appeals, and then it can be appealed from there to what are known as the 12th Circuit Court of Appeals, and from then, which is very rare, it would go to the
So it doesn't appeal directly to a court, it appeals to a board?
The board, it's just called a board, but it is in reality, it acts like a court.
It's in reality a court. Does it have the ability to hold someone in contempt of court, as do courts?
I'm sorry?
So can we agree that all courts have the ability to hold someone in contempt of court?
If the executive agencies agree to that.
Right,
yeah.
all right. Thank you. Now, if they are fleeing, if these children are fleeing, you mentioned from a violent area where their lives are at risk, do not people who are fleeing for, we would call that asylum, correct?
Some of them.
Okay. Now, if you're fleeing under the cause of asylum, do you not have a right, and are you not given an asylum officer?
It depends on the specific child. 23% of these children are eligible for what is known as special juvenile immigrant status, and 17% of them are eligible for asylum.
Okay, so why are the rest not
just
eligible for those?
And those are just the two most common ones. That was according to the American Bar Association. There's also the U visa and T visa for unaccompanied minors who are victims of human trafficking and other crimes.
Right. What lawyers are you going to be hiring? Where are we getting this supply of lawyers?
Right now, the way the federal government does this is that whenever they appoint counsel, they hire it from the private sector. There are at least 13,000 lawyers in the American Immigration Lawyers Association, as well as thousands of other lawyers and other nonprofit groups that are already, some of them are already representing these children for free.
Can we agree that, okay, so has the affirmative team shown that there is enough excess lawyers that do not currently have a job that they can actually staff the positions you're trying to staff?
If you bring that up, we would be happy to respond.
All right, thank you. Now, you said these, if these people have a legitimate claim, they'll be able to stay and they'll be able to be helped by a lawyer. How many of these children actually have a legitimate claim to stay in the United States?
According to the American Bar Association, which I just quoted earlier, at least 40% of these children are eligible under the law, and that's just counting the two most common, asylum and special juvenile immigrants.
All right, thank you.
Thanks.
Judge, all set? On the timer? And the affirmative. Great, let's begin. I want to really start off by addressing the philosophy behind the affirmative team's case. They have great merit, and we as a negative team recognize that. They want to provide counsel for immigrants who are unaccompanied, who don't have that provided for them. Now, we recognize that that is a noble cause. So as a negative team, we do respect that cause. So I wanted to take this speech and really represent how in the status quo, we as the United States are doing a lot to help those who are unaccompanied in the United States. But at the same time, we need to temper that with the reality that these are immigrants who are oftentimes here illegally. So we are in a delicate situation. So I want to explain to you how the status quo is handling it perfectly, and the affirmative team brings you disadvantages. But before I get into that, I want to briefly address topicality in today's debate round. Now, the resolution that we've been given today is that the United States federal court system should be significantly reformed. Now, the affirmative team is reforming the immigration services of the United States. They are reforming the Executive Office of Immigration Review, EOIR. That is what we call, in layman's term, the immigration courts. But in actuality, these aren't actually courts, they're administrative executive tribunals. Now, why this matters is because if they don't fall within the resolution, they do not fulfill their burden to do so, which is why I would like to present to you a few definitions. I'd first like to start with the definition of the federal court system, just as a general basis of what the resolution is speaking to when it says that the court system should be reformed. From the United States Department of Justice, they say, quote, the federal court system has three main levels: the district courts, the circuit courts, which are the first level of appeal, and the Supreme Court of the United States. Now, when we look at this definition, we see that that does not include executive agencies within the executive branch. But to highlight just exactly how the EOIR, or the immigration courts, are part of the executive branch and are indeed administrative tribunals, I have another definition from the United States Department of Justice that says, quote, the BIA, or the Board of Immigration Appeals, is the highest administrative tribunal for interpreting and applying U.S. immigration law. So this definition establishes the fact that it is an administrative tribunal. EOIR and the BIA, the immigration courts as we call them, are administrative tribunals. Now, to provide the definition that administrative tribunals do not fall within the federal court system, we have a definition from Cambridge Dictionary that says, quote, and this is the definition of an administrative tribunal. It says, quote, a legal organization that makes decisions in disagreements between two people or between a person and a government department, but which is not part of the court system, end quote. what we can see is that in the status quo, right now the immigration courts, as we do refer to them as, are indeed administrative tribunals, and per the definitions presented thus far, that does not fall within the court system. So the affirmed team is not reforming the federal court system, but in fact, they're reforming an executive agency. That is not at all the court system. But moving on past that into the more interesting arguments, as I like to think of them as, I'd like to start off with significance point 1, that in cases of asylum, it is non-adversarial. Asylum is non-adversarial. So this is alluded to in cross-examination. When these unaccompanied children immigrants are coming to the United States, if they are seeking asylum, if they are fleeing their home country for safety reasons, if there is not proper safety measures in place in their home country, if that is the situation, then their case is handled by an asylum officer, which is not in the courtroom, it is not against a powerful DHS attorney, and it's going to be very sensitive and tailored to the children in the case. To support this, I have evidence from Kate M. Manuel, who is the legislative attorney. She says, quote, any alien, regardless of age, may be eligible for asylum if the alien is unable or unwilling to return to his or her home country due to a well-founded fear of persecution. In general, an alien can either apply for asylum affirmatively with U.S. Citizenship and Immigration Services within DHS or defensively in the context of removal proceedings before an immigration judge. Asylum officers within USCIS have initial jurisdiction over any asylum claim made by a UAC, an unaccompanied minor, even if the UAC is in removal proceedings. In addition, other provisions of federal law make it easier for UACs to be granted asylum on account of persecution. End quote. So what's important here that I want to highlight is that in cases of asylum, an asylum officer has initial jurisdiction over the cases if it involves a UAC. Which means these asylum officers, because these people don't have legal counsel, because these children don't have parents with them, the asylum officer says, we're going to go over the case and see if you have merit to be here. Now, obviously, if they are found to be here illegally, and if they don't have merits for asylum, yes, they will be deported. But it will be handled in a non-adversarial manner. But if the asylum officer does determine that these children have a legitimate reason to seek asylum in the United States and have standing to be here, they will grant asylum. So the current system absolutely is protecting the UAC's rights to have protection in the United States. Now, my significance point 2 is that we're already spending $9 million for counsel. We are already spending $9 million for counsel. To support some evidence from USA Today that says, quote, this is from 2014, the Department of Health and Human Services announced Tuesday that the agency plans to spend $9 million over the next 2 years to pay for legal representation of unaccompanied minors. The money will help support programs that provide legal services to children caught crossing the border illegally and who are applying for asylum or other forms of protection from deportation back to their home countries, end quote. So we see that while in the current system, if they're seeking asylum, they are handled by an asylum officer. Furthermore, if the situation does indeed need an attorney, the Justice Department is already spending $9 million to provide this counsel for these children. So we see that the current system is absolutely meeting the needs and the demands of the unaccompanied children. But all of that being said, significance point 3 is that this is not a right. This is not a right. So we have to recognize that in the current system, immigrants do not have the same rights as American citizens. They don't have a right to counsel like we do. And so while they are in a difficult situation, and we as the United States government have recognized that, and so we do treat it as a tender situation, it is not a guaranteed right to have this representation. To support this, I have evidence from, this is the United States Code, Title 8, regarding aliens and nationality. It says, quote, in proceedings under this section, under regulations of the Attorney General, the alien shall have the privilege of being represented at no expense to the government by counsel of the alien's choosing who is authorized to practice in such proceedings, end quote. What's important about this section of U.S. Code is it says that they have the right to be represented, but at no expense to the government. The United States government is in no way obligated to pay for the legal fees of an alien in the United States. They can have representation, but it should not be free. Now, why this matters, and really how this manifests itself, is in the disadvantages of today's debate round. Disadvantage 1 is violation of federal law. Violation of federal law. Regarding the law that I just read to you, the National Review says, quote, Hans von Spakovsky, a senior legal fellow at the Heritage Foundation, points out that according to federal law, an illegal alien shall have the privilege of being represented at no expense to the government by counsel of the alien's choosing who is authorized to practice in such proceedings. Von Spakovsky says Justice AmeriCorps violates the stipulation at no expense to the government because of the Justice Department's involvement, end quote. Now, what the affirmative team's case is doing is they're taking money from the federal government and they're spending it to give representation for immigrants in the United States. But the law of the land says that there should be no expense to the government. They are expending the government's resources to provide this. That is a stark violation of the federal law as we see in the United States Code, Title 8. Now, the second disadvantage we have is American interests undermined. American interests undermined. And why this matters is because while aliens do not have a right to representation, neither do U.S. citizens in civil cases. So why would we choose to give our resources, if we have them, to immigrants when our own citizens don't get it in every single proceeding? To support this, I have evidence from John Fear, who's a legal policy analyst. He says, quote, "American citizens regularly deal with important civil matters without representation. This might include child custody cases, foreclosures, and evictions. Immigration attorneys are basically arguing that an alien facing a return home is more deserving of representation than a U.S. citizen fighting eviction from his home." Thank you.
Alright. Hi Michelle, I trust you're doing well. First off, the EUIR oversees the immigration courts, correct?
As the Executive Office of Immigration Review is what you're enacting, as your definition of the Board of Immigration Appeals, which is also part of that process,
Sure.
is an administrative
But the
tribunal.
EUIR oversees the immigration
We'd have to
courts.
see evidence to support that. They're actually courts and not administrative tribunals. Because the
Okay.
evidence we
So
presented
there's
is
the
that-
immigration courts, and if it's appealed from there, it goes to the Board of Immigration Appeals, and the EUIR oversees the entire process, correct?
We'd have to see evidence to support that.
Okay.
And that they're
Now,
actually
immigration,
administrative tribunals.
did you ever bring up a definition of what a federal court is? I know you read the definition of the federal court system, but did you ever read a definition of what a federal court is?
No, we did not.
Okay. Now, the federal court system is made up of federal courts, correct?
Absolutely.
Okay. Now, immigration law is a federal law, correct?
Yes.
And immigration courts apply and interpret federal law, correct? Or
We're
immigration
arguing
law.
that these are administrative tribunals,
Okay.
not federal
But
courts.
immigration courts apply and interpret immigration law, correct?
We're contesting that they're administrative tribunals, not courts.
But they do interpret immigration law.
Yes, but they're tribunals, not
Sure.
courts.
Now, your next point was how asylum is non-adversarial. Now, asylum is a two-step process. First, they go to the USCIS, which is the non-adversarial process, and then if they win, they go to the immigration courts, correct?
We'd have to see evidence to support that.
Your piece of evidence that you read said that there was two ways they could do this. They could go to the immigration courts, or they could
Right,
go
it
to
said
the...
you can apply for asylum either offensively or defensively, basically saying if you want to go initiate the process, you can, or if you're found here illegally, then it's going to be defensively.
Right. You'd agree that our plan is only applying to those defensively in immigration courts,
So
correct?
those who don't go through the proper channels that our laws prescribe.
I'm sorry?
So what it said is basically that you can either apply offensively or defensively. If you apply offensively, then you're coming to the United States and immediately you get here and you're saying, I'm seeking asylum, how do I do this legally?
Yes.
If you're doing it defensively, you come here and you don't go through any legal channels and you're found to be an illegal in the United States, so you are a criminal.
Yeah, those in the
offender.
immigration courts, correct, are defensively.
Yes.
So you would agree we're only dealing with those in the immigration courts?
Right, so my point is that if you
Sure.
seek asylum through the proper channels, that will not be an issue.
Okay. And all 68,000 unaccompanied minors that we talked about were in the immigration courts, which are defensible,
I'm
correct?
not aware of the specifics on those,
Okay.
I'd have to look back.
You said that we provided 9 million in counsel. You would agree that that was in 2014, correct?
It was over a 2-year period, so it'd still be continuing to today.
Could we see evidence for that?
Yeah, absolutely. The evidence said that it was going to be over 2 years.
You'd agree with me that that only covers 2,600 unaccompanied minors?
We'd have to see evidence to support
Okay.
that.
Now, you also said that it's a violation of federal law. Now, to pass a new plan, don't you have to be in violation of previous law? If the federal law didn't prohibit our case, wouldn't our plan already be passed?
No, not necessarily.
You would agree that in our mandate it says we're reforming current federal law, correct?
Yes, but you do not specifically say what law you're reforming, and as you can see, you're not amending the United States Code Title 8
So,
per your mandate.
okay, and in civil
Here's the
cases,
evidence,
okay,
and it says
do
so.
in the current system, U.S. children already have lawyers, correct?
Yes, for most cases, but my point was that in civil proceedings, many Americans who are still in a very difficult situation are not being given representation.
Okay, thanks, Michelle, I'm out of time.
Thank you.
I'll take 5 time and 30-second intervals, please. set? My opponents?
Yes.
Alright, then let's get started. Currently, we have a problem within our immigration courts. Immigration judges make a ruling with one side of the facts. And then, based on that ruling, an immigrant is either allowed to stay in the United States or ruled to be deported. But the problem is, in the status quo, a lot of immigrants aren't showing up for their court cases. So what's happening is, even if a judge orders these people to be removed, nobody can find them to actually remove them. And this is backed up by Sarah Pierce in a report from the Migration Policy Institute. She says, quote, most removal orders go to children who fail to attend their hearings, and as a result, many removal orders go unexecuted. So let's ask ourselves, why aren't these children showing up for their court cases? Well, the answer is that the government is rushing these notifications. Basically, they're sending a child a notification saying you have to be in court today or tomorrow. And sometimes they're not even delivering them to the right address, according to Stacey Jones. So what's happening is the government is removing these children in what's called absentia, where the child does not appear in court. So what's the solution to this? Well, the affirmative policy is the solution to these unenforced deportation orders. The affirmative policy would help improve the process of deportation for children who need to be deported. A study by the Immigration Policy Center looking at 10 years of government data concluded that a child is 3 times more likely to appear in immigration court when represented by an attorney. So what we can see is that when children actually appear in the when they show up, they are 3 times more likely to do so when they have an attorney. And the National Association of Immigration Judges in 2013 wrote that, quote, represented individuals are more likely to show up for their hearings in immigration courts and thus less likely to receive an absentia removal order. Reduction of in absentia orders would limit the number of cases that warranted reopening, and it would also minimize the need for immigration and customs enforcement resources to be directed towards apprehending individuals with outstanding warrants of removal. And so what we can see is that the affirmative policy would be effective in ensuring that the people who need to be deported are deported without extra cost. That is the benefit of the affirmative policy. Now let's look at the specific arguments and show how to achieve justice in our court system, to improve efficiency and accuracy, you need to pass the affirmative policy. First, let's look at the idea of topicality, because that was the first argument that was brought up by the negative team. Basically, they had 2 points under this. First of all, we are reforming the EOIR, and then second of all, they presented 3 definitions. Let's look at the first part, which is the EOIR. I have 2 responses. First of all, the EOIR is the oversight agency of the immigration courts. It's the oversight agency of the immigration courts. In other courts, you have what's called the administrative office of U.S. courts. Those are oversight bodies. They are not necessarily part of the courts, but they are the oversight body. We are reforming the immigration courts, not the EOIR. That is a misconception in the negative team. And then the second part to their topicality argument was that of definitions. And then they brought up one definition that said there were 3 different levels of the court system. Then they talked about the United States Department of Justice definition about the Board of Immigration Appeals. And then finally, they talked about the administrative tribunals, basically. Let's basically break this down and ask ourselves, what is a federal court? Well, first of all, it's on the federal level. That's obvious. We can all agree on that. And then what does a court do? Well, according to U.S. legal, a federal court enforces federal laws, rules, and regulations, and applies and interprets the Constitution of the United States. And in our 1AC, we presented a definition of the federal court system from FindLaw, and they say, quote, federal courts handle all immigration, bankruptcy, copyright, patent, and federal criminal cases, unquote. So what we can see is that currently what is happening is that the immigration courts are in the federal system and they operate exactly like a court, and they're under a definition of the United States federal court system. This brings me to my second response to their definitions, which is that there's no reason to prefer. There's no reason to prefer. We presented our definition in our 1AC. They gave you absolutely no reason to prefer their definitions over ours. There's absolutely no reason to think that an immigration court is not part of the federal court system. It looks like a court, it acts like a court, it is a court. Now let's move into their significance points, which the first one was asylum is non-adversarial. Asylum is non-adversarial. And their point under this was basically that these cases are handled by an asylum officer. I have 2 responses. First of all, it's a 2-step process. It's a 2-step process. First of all, the asylum officers have initial jurisdiction. That was what the negative team's own evidence said. It's initial jurisdiction. But then the second step of the case is actually going to the immigration courts, where the counsel is needed, because that becomes adversarial. And in cross-examination, it came out that the only cases that are heard within the immigration courts are defensive cases where the process is always adversarial when it comes to the courtroom proceeding. There is no non-adversarial court proceeding within the immigration court system. So this is an adversarial process where you do need representation, because when you have an adversarial process, as the opening quote to R1AC said, you have to have both sides in order for the facts to emerge. You have to have both sides in order for the facts to emerge. And then their second significance point was that we're already spending $9 million on counsel. We're already spending $9 million on counsel. Looking at their specific piece of evidence from USA Today, they conveniently cut out a part right in the middle of the evidence that says that the funds will only represent 2,600 immigrants. They conveniently cut that out. So let's look at exactly what these funds are going to do. Out of the 68,000 unaccompanied minor cases in the federal court system right now, or in the immigration courts, the affirmative team, or the funds that the negative team is claiming are effective, are only representing 2,600. That is woefully ineffective and insufficient. We need to fund representation for all of them in order to achieve efficiency and accuracy, and therefore improve the justice in our court system. And then their third and final significance point was that it's not a right. And we completely agree. It's not a right. I have two specific responses to the idea that we don't grant counsel just because it's not a right. My first response is that if it was already a right, there would be no need for our plan. If there was already a right, there would be no need for our plan. And then second of all, federal law does not prohibit our plan. Federal law does not prohibit our plan. There's nothing in federal law that prohibits the affirmative policy. Now, there was a piece of evidence that the negative team brought up that was about costs, but it never talked about a legal right or ability to have counsel. In fact, that law says that counsel can be granted. Now let's move into the disadvantages, which we'll be talking about that same piece of evidence again. First of all, they claimed it's a violation of federal law. I have one response. We are reforming federal law. We are reforming federal law. That was the first line in our mandate. Federal law, U.S. federal law shall be amended in order to provide counsel for unaccompanied minors. And there is legal doctrine that states that when you pass a new law, it overrides previous law. That is how the legal system works. There is no reason to believe that this law would in any way prohibit the ability of our plan to be implemented. And then their second disadvantage was that American interests are harmed. I have two specific responses. First of all, in every single case where a U.S. citizen is going against the government, they are represented. In every single case where you are going against the government, you're represented. The only time you're not represented in U.S. federal court is when you're going against another U.S. citizen. There's no need for representation in those cases. And then my second response is that the Supreme Court ruled that there is a differentiation between civil and immigration cases. Thank you.
Interested in doing well this morning, Sam, just a couple questions for you. Starting off, what percentage of the immigrants, the UACs right now, would you say have a legal basis to stay in the United States?
A legal base, looking at the two specific types of asylum, or two main types, over 40%.
Okay, so roughly 40% have a legal claim?
It can be over that, because that's not looking at the 6 other types of immigration relief that are available for unaccompanied minors.
But for the affirmative team's evidence that you've presented and are claiming 40% have a right potentially to be here?
That's a solid right, because
right,
based on the 2 current types.
Okay, absolutely. And how often in court, what percentage of children are granted citizenship?
The immigration courts don't actually grant citizenship.
Or not citizenship, but legal status.
Legal status. I have those numbers back in the table. I can't give you one off the top of my head. I'm sorry.
Okay, absolutely. Now, did you ever read evidence in your speech saying that the EOIR was a court?
EOIR, we don't need to claim the EOIR as a court because we're not reforming the EOIR.
Did you read any definitions that said what you're reforming is a court? And versus an administrative tribunal?
I read evidence that says the federal courts handle all immigration.
Right, but that doesn't actually say that the EOIR or any courts involved in that are courts.
We don't claim the EOIR as a court. The EOIR is an oversight body of
Right.
the immigration courts, just like the Administrative Office of the United States
Sure,
Courts
absolutely.
oversees.
Would you agree that the
federal
Board of
courts.
Immigration Appeals, which your plan also affects, correct?
It will affect the cases going to the.
Right, absolutely.
That will be appealed to it, yeah.
You would agree that we read evidence saying that the BIA is an administrative tribunal, not a court?
But I countered that with a US legal definition that stated that all courts handle and interpret federal laws, rules, and
That
regulations.
federal courts can handle immigration, but would you agree that our definition did say it was an administrative tribunal?
Sure, it could have, but
Okay.
basically what we're looking at is what is the federal court system, and the federal court system enforces and interprets federal laws, rules, and regulations, which is exactly what the immigration courts and the Board of Appeals do.
Alright, thank you. Now, does the EOIR follow, or any courts over it or under it, does that follow the rules of civil procedure?
I'm not sure if they follow the rules of civil procedure or if they have to be determined to court.
Okay, are they under the Administrative Office of the United States Courts?
I don't believe so.
Okay, so you'd agree that the Administrative Office oversees most of the courts in the United States federal courts?
There are courts in the federal court system that are not overseen by the Administrative Office.
Okay. Now you would agree that if you're applying offensively, if you are an unaccompanied children and you're applying offensively for immigration, would you agree that in that situation, your case is handled by an asylum officer?
I believe the large majority of cases are actually handled defensively where there is an adversary.
Okay, so it's when they're found here illegally and they didn't go through the legal channels prescribed by law.
There aren't many unaccompanied minors. The majority of that are going through the offensive measure because the majority of them are fleeing violence across the southern border, so
Right.
they don't have the time or ability to go through the lengthy process that is prescribed.
Okay, and your mandates do not specifically say that you're amending US Title VIII, correct?
When you pass a new law, it overrides the previous
Did you
law,
read
so
evidence
don't
to
have the
support that
specific-
statement?
It's a legal doctrine. I'm not sure
But
if
you
we have
did
the
support-
specific doctrine back at the table.
Okay.
There is an Oxford Dictionary definition.
We'd
I'm
love
not
to
sure
see
we have
that.
it. All right,
Thank you.
Start time, please. Thank you. Thank you. Wait, hold on. Actually, go ahead and keep going. Thanks. Is the judge set? Alright, we'll go ahead and get started. talk about a little bit about improved accuracy. One of the bulwarks between the negative team and the affirmative team that the affirmative team builds their ground on is that they're going to improve the accuracy of the EOIR's proceedings. And essentially what they're claiming is that if you have a lawyer representing these juveniles, that they're going to have more accurate verdicts. Now, the first thing that we should mention is that once we subtract all the people that either apply and are eligible for special programs and all the people who apply and are eligible for asylum status, once we take the remainder of those people, the vast majority of those people are here illegally. I don't think that's any secret that the vast majority of people that end up in the EOIR are there because they were caught in the nation and didn't have any paperwork to prove that they were allowed to be there. That being said, we got to realize that once we take out the subsets of people that qualify for programs to allow them to stay here when they don't actually have a legal basis for it, we got to realize that most of those people should not be here. That being said, when the affirmative team claims that they're going to improve accuracy, essentially what they do is they look back at studies that say if we give people an attorney, they're more likely to win their case and be able to stay. I want to point out that does not mean that they're more likely to be able to stay here legitimately. All that means is they're more likely to be able to stay, or they're more likely to win their case. That does not, all that means is that the lawyer was able to prevent the EOIR from proving to their standard that they were illegal. It doesn't mean that they proved that they were able to be here. It means that the direct, specific charge that the EOIR was bringing to them was shot down by the lawyer. That does not mean it was a more accurate verdict, and the affirmative team, if they want to claim more accuracy, which is if they don't improve accuracy of the verdicts, the effect of their plan is essentially not. So they have to be able to show that the people that they're actually going to be preventing from being kicked out of the country by giving them representation are actually able to be here legally anyways, that they're not just simply winning their case. With that being said, let's talk about the complexity of these proceedings. Now, they read an example in their 1AC of I believe it was a 3-year-old child. Now, I'd first like to point out that the vast majority of these people are not going to be 3 years old because they were able to sneak into the country illegally in the first place. Toddlers don't do that. With that said, let's actually think about what you would be doing in the EOIR. You're put in front of this board, and you have to essentially prove that you have the ability to be in the country. Now, either you do or you don't. I could pull out my driver's license and show that, and that basically demonstrates that I'm a citizen of the United States, and it shows my address, and it has identification information on my ID. People who do not have a driver's license, people who are here from another country that have, whether or not they're citizens or whether they're here on a visa or whether they're here on a green card or whether they're here for some other reason that they've got legal standings, they'll have paperwork to prove it, or they'll be in the system and they have identification to identify which person in the system they are and what their legal status is. This is not something like out of Law and Order, where it's a lengthy criminal proceedings where we've got evidence and he said, she said, and complex documents. Either you have the paperwork to prove that you are a citizen and have the right to be here, or you don't. You do not need a lawyer to help you game the system or to walk you through these proceedings. It's just not that complex. If you were savvy enough to get into the country without being here legally, you're savvy enough, if you are here legally, to be able to show that you have the documentation to be here. It's just not rocket science. With that said, let's talk about the quality of counsel. Now, actually, before I go into this, let's talk a little bit about where they're getting their counsel. Now, I asked them a cross-examination. Obviously, this is going to require quite a large number of counsel. With that said, where are we going to get it all? Because lawyers are very expensive. And the fact is, the government does not pay attorneys very well. Working for the government as an attorney, my dad's an attorney. It's not something you want to do. It's kind of a job of last resort. Typically, when you look at attorneys working for an administrative organization of the government. Here's the thing. When I asked them, I said, where are you going to get all these? And they said, oh, it won't be a problem. We've already got a bunch of lawyers who are doing this for they're volunteering with volunteer organizations to do this. Now, there's either one of two ways you could look at that. You could either look at that and say, because people are volunteering through these volunteer organizations to do it, there must be a plethora of lawyers that would be willing to do it for, the relatively, as far as legal terms, lousy government wages, which they still haven't demonstrated. That just because there are people willing to do it for volunteer organizations doesn't mean that there's actually a plethora of lawyers waiting to be hired for this position. B, if they're arguing that that we've already got a bunch that are doing it for free, so why wouldn't they just do it? I mean, of course they'll do it if we pay them, we gotta realize that they're already doing it. So if they try to hire the lawyers that are doing it for the volunteer organizations, they still have the same number of lawyers doing the task. If there are 1,000 lawyers volunteering to do this, and they hire those 1,000 lawyers, all they did was take the lawyers that are volunteering and started paying them to do the same job. They still haven't shown that there's actually an ability to hire this much counsel for this position, and that's something they absolutely have to do in a policy debate. With that said, let's talk about the quality of these lawyers. I want to quote a New York immigration study. It was published in 2011. It said, quote, this: "The study group on immigration representation observes that with these preliminary findings, which show quite clearly that those with legal representation fare far better than those without, do not address a critical problem that needs to be examined in future analysis: the lack of adequate counsel and its impact on the administration of justice. Evidence suggests that major problems exist as to the quality of representation, even in substantial numbers of non-detainee cases where relief ultimately is obtained. One indicator of the extent of which this problem is that there are currently 52 New York attorneys that have been either expelled or suspended by the EOIR from the practice of law before the immigration courts and the Board of Immigration Appeals. In all too many cases, the already overburdened immigration judges In all too many cases, the already overburdened immigration judges expands considerably with their effort when doing the jobs that the lawyers are supposed to do." Close quote. Essentially what they're saying is the lawyers that they get to do these jobs are not the greatest. Think about it. Any lawyer would rather work for a law firm. They would rather work in-house. But instead, the lawyers that they get for these government jobs just aren't that good when we're looking at the Executive Office of Immigration Review. Now, let's look at what we value. I'll tag this one as where are our policy priorities? Where are our policy priorities? And I believe the affirmative team is trying to take us into a place with policy down a road that we do not want to head. Now, essentially, we have courts all throughout the United States, civil and criminal, that have 3-4-year backlogs where people have issues that need to be adjudicated, and they have backlogs. And frequently, many of them don't even get free representation. Now, when we look at the people that have a constitutional right to our adjudication services, which are citizens of the United States, that are being denied these services temporarily, or sometimes in some cases indefinitely, and then we have children, forget the fact that they're children, that's just an emotional appeal, that are not citizens of the United States, they do not have a right to be here, they do not have a constitutional right to any of these services, and if we can find wiggle room to increase capacity within the system, and we're giving it to the people that do not have a constitutional right to adjudication services, we're putting our policy priorities in the wrong area. And that sets a precedent, and not only does it take us in this specific instance in an area where we should not go. If we've got this ability to increase the capacity, we should take it elsewhere. This sets a precedent that is not something we want to head down when it comes to policy. Now this is a disadvantage, and also, again, I'll expand on this later, is that essentially it encourages illegal immigration, because essentially what these people are doing is they don't have to fear the U.S. government. They know that the U.S. government is going to work for them if they were to ever get caught. They're going to provide them an attorney. So it's for all these reasons that I strongly urge you to think about. Thank you.
Hi Elijah, my first question is, would you agree that in the current immigration court system that only one side of the facts is presented?
No.
Alright, would you agree that one side is only the child?
In some cases, yes. In some cases, they have asylum officers that are with them if they qualify for it.
Okay. And would you agree that only about less than 19% qualify for asylum?
Yes, and the other 19 likely shouldn't be here.
Okay, alright. Now, would you agree that courts should make the correct decision?
Yes.
Alright. Now, do you find it easier to make a well-informed decision when you have both sides of the facts?
Yes, but that's assuming, you're again implying that just because the children doesn't have a lawyer to demonstrate that they have legal status to be here means that they're not getting both sides of the story.
Okay. Now, so it was your claim that everyone in the immigration court has to have papers in order to stay, correct?
No, either you can demonstrate that you are legally here to stay, or you can't, and it's
would you agree that in the instance of children, visas can be granted after they cross the border?
Yes, in which case that would be considered an asylum officer, or they qualify for specialized programs.
Specialized programs that are not part of the asylum program, correct?
Yes.
Alright. Now, did you read any evidence about the majority of people that have papers?
No.
Okay. Now, you claim that it was our contention that children are more likely to win with a lawyer, right?
Yeah, I mean, that's
Alright,
true.
what part of our case did we say that? Where in our case did we say that?
I mean, second page, I don't know where in your case you said that.
Okay, did we say it at all?
Yeah, I believe you said that they get more accurate decisions with.
Does an accurate
attorneys.
decision necessarily mean the child stays?
Mean the child's what?
Does an accurate decision
No, that's
necessarily
exactly
mean
my
the child
point.
stays?
There's no reason to believe that. I mean, the only result that you can have from getting a lawyer is that your chances of winning goes up. That doesn't mean it's more
You could have
accurate.
immigration judges in the status quo making the wrong decision and not having a child deported, right?
That's true, but giving
Okay.
a lawyer is just gonna make that problem even worse. Because it's just going to encourage them to allow us to
Interesting.
say, because they're gonna have advocacy.
Alright, did you ever respond to the study about voluntary departures in our
Which study was that?
It was the one under justification one.
What topic? And what did it
It-
advocate for?
We'll talk about it later. Alright, now, how much is the, I'll use your words, lousy government wage for an attorney?
Yeah, what's your question? What's
How,
the wage?
how much is it?
I don't know how much it is. All I know is that if you can get out of the government as a lawyer, you typically always get another job after that.
Interesting, alright. Now, pro bono attorneys work for free, right?
I don't know if they do or not.
Okay.
I know
Does
some
pro bono
do.
mean free?
Yeah, sure, we'll
Isn't
go
that
with
the
that.
general idea? Okay. Now, you mentioned that there was significant backlog in the civil courts, right?
Mhm.
Alright, now, how large is that backlog?
In some cases, it's upwards of 4 years.
Interesting. Alright, can I have the, evidence about the, bad quality lawyers?
Yep, there you go.
And can I have the evidence about the backlog of 4 years?
No, I didn't read evidence of backlog.
Okay, great, thanks.
Right. Fine, take your time. All set. And Zimmer, and the affirmative team? Alright. I think a big question that this debate round comes down to is finding a balance. Finding a balance of assistance and American interests. And so we have to find the balance of where it's, we don't have a right to do this, we don't have to do this, but when should we choose to do it? When is it in our interest to do this? So in the framework of that question of where the balance and where that line should be drawn, I really want to be centralizing my speech on that point. Looking at the assistance we're giving right now and how that is adequate, given the fact that we don't have any burden to give any assistance at all. And then second, looking at how are American interests going to be played out under the affirmative team's plan. And how will they be harmed and how is the current system protecting them? But before I get into that, I want to briefly touch on topicality, which I don't think anyone really enjoys topicality arguments, but I do think it does have merit in today's debate round. So, the main contrast between the negative and the affirmative team regarding topicality is that we have provided you with specific definitions. The affirmative team has read one definition in their 1AC saying that federal courts handle some immigration cases. Now that does not mean that the Executive Office of Immigration Review or any administrative agencies or tribunals associated with it are courts. Because we, in fact, read evidence saying the contrary, saying that the EOIR and the BIA, the Board of Immigration Appeals, all those are administrative agencies. And then we read a definition that said administrative agencies are not within the court system. We provided you with specific tailored definitions saying they are administrative agencies and they're not the court system. They have not directly refuted that with evidence. Why this matters is because at the end of the day, we provided you with the standard that the affirmative team has not met to fulfill their resolutional burden. But moving on from that, I want to be looking at the assistance that right now we are giving these illegal unaccompanied children. Now, but before I get into that, my first point is that it's not a right. So any assistance that we're giving, we're doing in essence out of the goodness of our heart. We're choosing that this is a good decision. We do recognize they're in a tough situation, so we do want to help them, and we are helping them. But we have no obligation to do so under any legal standing. That being said, My second point under assistance is that of asylum. If you are seeking asylum, and if you apply offensively or affirmatively for U.S. citizenship, you will be given an asylum officer. So if you follow the legal channels that we say you have to follow, you don't have to go to court. You don't have to have an adversarial proceeding because you did it the way that our laws say you have to. We absolutely bend over backwards to help unaccompanied children if only they follow the laws of our land. Now, the impact of this is that we can't do anything different. If we encourage them to break U.S. code and then we say, well, we're going to give you this assistance regardless of whether you do it the right way, that incentivizes people to do it the wrong way. That's not policy we want to enact. So in the current system, we're finding the balance of helping these people when they're seeking asylum, but still incentivizing them to do it legally. That being said, my third point is the money that we spent on this already. We are spending an exorbitant amount of money on immigration proceedings in the current system, and specifically for counsel for unaccompanied children, we have spent $9 million, which our evidence said is going to be from 2014 to 16. The program is still ongoing in the current system to provide counsel for unaccompanied children. Now, their response is that this is only 2,000 immigrants and that's not enough. Listen, I agree. That's why it comes down to the fact that we are doing this out of the goodness of our heart. We're saying we're going to give you some counsel, we're going to do some, but we're going to draw the line and say we're not going to spend all the taxpayer money that we have to provide this immigration. You have to find a balance, but we are taking steps to help them. Now, that being said, the second point I really want to talk about is the rule of law and what that looks like under the affirmative team's plan. First of all, because they're giving assistance to people who follow the system legally or illegally because they don't discriminate based on those who do it the right way, you're undermining the rule of law because you're encouraging people to do it illegally and still rewarding them for that activity. Secondly, they made the claim that any time that you create new legislation, it amends all of the other legislation that ever happened regardless of what you say. Now, in their mandates, they did not say that they were amending U.S. Title VIII that says that there should be no expense to the government to pay for immigration costs. So they did not specifically say that, and they said that they had evidence to support the fact that it's true, that legal understanding is that it will retroactively amend every other law. That is not true. They have not supported that. We need to see evidence that's actually going to be the case, because most legislation that is drafted has sections where it says, because we're doing this, we're going to amend this law, and this law, and this law. They don't say that. Why that matters is because they're going to be creating policy that is in stark violation of U.S. federal law, and unless they amend it, that will create inconsistencies. Now, lastly, all this comes down to American interests. At the end of the day, we're going to be spending exorbitant amounts of taxpayer money on rights that are not guaranteed, when in fact, U.S. citizens aren't getting representation in their own civil cases. So why are we prioritizing illegal immigrants over U.S. citizens? If they don't get the right, why would we choose to give it to them first? And the impact of all of that is that it incentivizes illegal immigration, because if you're an immigrant in another country, and if you know that if you come to the United States, you are guaranteed free representation, that's a pretty good incentive to come here. Because regardless of what you do, you know you're going to get a lawyer to defend your case. A worst case scenario, you're back where you started. At the end of the day, this is not policy that protects American interests or the rule of law, which is why I strongly urge negative ballot. Thank you.
Take prep time 30-second intervals, please. All right, no further prep time needed, thanks. Judge ready? Tanner? And then all right. I'd like to bring you back to the goal of this debate round, justice. The negative team has been unable to bring up an alternate goal, so therefore you should weigh this round on whether we improve the efficiency and accuracy of the cases. We never claimed we were doing this out of a moral obligation. We said you should pass our plan because courts should make the right decisions and they should do it quickly, to save money for U.S. taxpayers, which is what our study said, to reduce the backlog, to uphold the rule of law. More children will be deported under our plan, something the negative team has failed to look at. That's what I'm going to be looking at. But before I get into specific arguments, I'd like to note that many of the negative team's arguments were not substantiated by any evidence. They did not have any evidence on the point of no identification of papers. That the reason that there's no lawyers is because of government waste, that there's 4 years of backlog, that these children are breaking U.S. code, that there'll be more increased illegal immigration. They read no evidence to back up this. But let's look at the specific argumentation. First of all, because this is a team policy debate around topicality. My first point is the definition of a federal court. First of all, federal courts interpret federal law. My partner read this from a legal dictionary, which is actually one of the best legal dictionaries out there, and it says that federal courts interpret federal law. My second point is that immigration courts interpret federal law. Immigration courts interpret federal law. I asked the negative speaker in this cross-text, and she agreed that immigration courts interpret federal law. And my third response is that federal court system is made up of federal courts. The federal court system is made up of federal courts. Again, the negative agreed that the federal court system is made up of federal courts. Because immigration courts interpret federal law and federal courts interpret federal law, the immigration courts are therefore a federal court and under the federal court system. My fourth point is that we're not reforming the EOIR or the BIA. We're not reforming the EOIR or the BIA. The EOIR is the administrative agency that oversees them, and the BIA is the appeals court. If the case is appealed once the initial decision is reached, then it goes to the BIA. We're not providing lawyers in the BIA, just initial cases. Thus, it's not relevant to say that we're reforming the BIA or the EOIR. Now, they said that our study was flawed because we said that more are likely to stay under our plan, and that doesn't mean it's legitimate. My first response is that misconstrued. We never said that children are more likely to stay in general. What our evidence said, which was a study, that if the child is eligible under the law, they will be more likely to stay. My second response is that we increased deportations for ineligible. We increased deportations for ineligible. Under our plan, which the negative team did not respond to our study, there will be more deportations for children who are not eligible. They said that there's no identification of papers. My first response is no evidence. No evidence. But my second response is evidence. We as the affirmative team have evidence to the contrary. Annie Chen at the American Bar Association said, children must testify under oath, plead to government charges, tell the judge what forms of relief they wish to pursue, file applications for relief and supporting documents in English, testify and call witnesses with no knowledge of the legal norms and customs. Now that was a lot of things that children have to do, but they have to testify, plead to courts, provide relief, and they have to provide documents showing they have persecution in their home country. So yes, they do have to have paperwork. Only lawyers can do this. They also asked, where will the lawyers come from? My first response is lawyers are available. The negative team agreed that there are about 13,000 American immigration lawyers. There's 13,000 lawyers in the American National Association of Immigration Lawyers. My second response is that we did it before. We hired lawyers to prosecute these children. These are trained government lawyers. The federal government has done it in the past. We've done it with every single criminal case for United States citizens. We can do it again. My third response is pro bono or overburden. The reason why pro bono are not able to represent these children is that they have to operate for free. So of course they're not going to be able to do it. If we give them money, they will be able to do it, which is my fourth response, $8 billion. We are providing a lot of money so that these people will have a large amount of salaries. That's a financial incentive for them to take the cases. $8 billion is a lot of money that we're going to be spreading out for the cost of these lawyers. They also said that there's a lack of quality representation for these lawyers. My response is that's actually about current lawyers. That was actually talking about the current pro bono lawyers. And we agree, they have a lack of quality representation because they have to operate on a non-profit basis and they're stretched with every single case. So of course it's going to be a lack of quality representation. Now let's talk about whether or not there's a legal right for them to stay here. My first response is if they had a legal right, our plan would already be passed. If they had a legal right, our plan would already be passed. They dropped my partner's response. My second response is for the sake of justice. For the sake of justice. We never claimed that there was a constitutional right for these children, but we're doing it for the sake of justice, which is the negative team has not agreed, has conceded. Now let's talk about asylum. Our plan only applies to children who are defensively. There are 68,000 unaccompanied minors who are in the courts defensively. That's what we're fixing. And about increased illegal immigration, according to the American Immigration Council, children are coming because of violence. And Tom Wong found a relationship between violence and the amount of children coming. So they're not coming because they think they can win their case, but because of violence. But because we uphold justice, I urge an affirmative ballot. Thank you.